Welcome back to the Vault. I'm Mike Ricola, where our goal at the Nande Filmmaking Legal Lab is to democratize access to educational resources so that every filmmaker knows their rights. Get smart with us. So today, we're talking about hustle. You find an incredible unproduced script. You don't have 10,000 to officially option it. So you shake hands with the writer and agree to shop it to your studio contacts and streaming contacts. Pitching without upfront cash is smart, but doing it without a tailored shopping agreement is how indie producers get destroyed. Here's the nightmare scenario. You leverage your entire network. You pitch the script to a major buyer. The buyer loves it, but there's a catch. They want the script, but they don't want you attached as the producer. Or your informal 6-month shopping window expires, and the writer quietly signs a deal with the exact studio you introduced them to the very next day. You get no credit, no back end, and $0 for your months of hard work. You need this shopping agreement. It gives you the ultimate $0 option to shop a property, while installing ironclad legal traps to ensure you never walk away empty handed. Before you download this template, we need to have a quick talk about the rules of engagement. I am a producer and I am a lawyer, but I am not your lawyer. The templates inside the vault are the exact legal armor used by professionals. They are provided for educational purposes only. Downloading this document, watching this video, or reading my breakdowns does not create an attorney-client relationship between you and the Nande Legal Lab. These templates are your starting point. They are drafting tools designed to give you leverage. They are not a substitute for specific legal advice. Second, jurisdictions matter. This armor is forged using general principles of U.S. contract law and standard industry practices. But the rules change when you cross state lines and international borders. What works in California might have a different nuance in New York or London. You are strongly advised to have your final paperwork reviewed by local counsel in the state where you're shooting. Finally, use this at your own risk. You are the producer. You're the one stepping on set. The Nande Legal Lab assumes no liability for any errors, omissions, or legal consequences that happen because of how you execute this document. You're building your own business. Take responsibility for your own assets. Read the full disclaimers below. Now, let's talk about some quick usage notes. So again, this is a shopping agreement. A shopping agreement differs from an option agreement because you are the producer. You're not paying the writer any upfront money. In exchange, the writer retains the rights to approve or reject any final deal. So one of the things you got to be careful about is the ghost deal. So there's a tail period written into this agreement. The biggest risk of a shopping agreement is that you pitch the script to a studio, the clock runs out on your term, and the writer quietly signs a deal with the exact studio the next day, cutting you out. Section 3, the tail period, legally guarantees you get paid if a deal closes with your contacts after your contract expires. And then the ejector seat. What happens if Netflix loves the script but refuses to hire you as a producer? 5B ensures that if the studio forces you out, the writer has to buy you out so that you never walk away with nothing. Okay, let's look at the agreement. Up top, you see the common recitals. Who's it between? The date, you, the producer, and the writer or the creator of the work. The property is the work. Here, this is the clause that establishes that you have the rights to pitch, shop, and submit the property to any third parties, networks, or studios. One quick drafting note is always push for exclusivity. If it's non-exclusive, multiple producers could pitch the exact same material to the same studio executives, and this makes you both look highly unprofessional. There's always a term associated with these agreements, so set it up to whether it be 6 months, 12 months, 24 months. Then there's a post-term tail period. This is where you want to put in a date of number of like 5 to 10 to 15 days, where you, the producer, has to provide the buyer with a list of everyone you met with, so that if in the next couple months, say 12 months, following the expiration of this term, then the owner enters into an agreement with one of those buyers that you are compensated for that. Number 4 establishes that compensation in separate deals, meaning that the buyer of the project must set compensation with you yourself, the producer, as well as the writer themselves. There's an attachment floor. So if a buyer is secured, the producer shall be attached to the project, receiving no less than these credits, as well as a minimum guarantee and back-end percentage points. And then there's a buyout, because what if, again, Netflix wants to buy the idea, but they don't want you attached to it? So here's where you'd set your buyout. Then this is the approvals clause that simply states that the owner has the actual rights to approve any any deals. And then third-party attachments. We will put this in here to protect you, the producer, You really don't have any right to attach anyone to a project because, again, it's not fully optioned. It's just a shopping agreement. So this states that you can't do that unless you have the writer's permission or the owner's permission. Then representation and warranties. Basically, the owner is the sole owner of this property, and that the owner has legal capacity to enter into this agreement. Indemnification. This is where you have your indemnities, where you want the owner to hold you harmless from any claims or liabilities resulting in any breaches of him saying it's not their original work. Reversion. If there's no agreement reached between the buyer during the term or the tail period, all rights to the property automatically revert back to the owner so that they have free and clear title. But the pitch materials are still yours. So if the writer uses them, they are going to have to pay you a fee that you put in here. Then we have guild compliance, where you want to make sure that you are within compliance with the Writers Guild. And then finally, our miscellaneous provisions like your independent contractors, the governing law of the state. This is the entire agreement. There's no injunctive relief. If they sue you, they can only sue you for monetary damages. And severability, if anything, is deemed illegal in this contract, it'll be null and void, just that section, not the full contract. And then you have your typical signature page. So again, this is your typical shopping agreement. Use this if you want to have a zero upfront dollar exchanged agreement with a writer to go out and pitch this properties to studios or any potential buyer. So what's next? The shopping agreement bridges the gap between the independent hustle and the studio realities, ensuring that your sweat equity is legally protected. So download the template in the link below, track your pitches, keep a flawless record of who you submit your pitches to so that when the tail period comes, you have those names on a verified sheet, and then set your buyout. Agree on your eject receipt fee before you ever step foot into a pitch meeting. So stop giving away your network for free, secure your leverage today, and let's get back to work. Thanks for tuning in.